we'll put it in, and what I may do is keep things parallel for a while. That's what I need to see. Yeah, pull all that stuff up there out.
All right, can they hear me? Yes. All right. Morning, everybody.
Morning.
Morning, Your Honor.
Mingo. Judge Kathleen McHugh. I will magistrate here this morning. I have reviewed all of the probable cause affidavits in regards to each of your cases. I will make a finding of probable cause or not, and set bonds respectively.
Sierra.
Do you have any children?
The case I have is Michael Gutierrez.
Do you have friends in your
Who are we looking for, Judge?
Page 14, Michael Gutierrez. Do you have counsel present in court, I understand?
Judge, no, ma'am. I'm a family friend. This was one of those incidents where there's a bunch of witnesses involved, and everybody said the same thing. This is his wife. This is his mother. I'm a family friend. This is the paternal grandfather of the child that was involved. He's a U.S. Customs agent, and we're all here on Michael's behalf. There was no robbery. My name is Richard Diamond, Your Honor.
Okay, and would everybody else please state their names?
Maribel Estevez, Michael's mother.
Your name is Daniel.
Gutierrez, you here this morning?
Yes.
Robbery with no firearm or weapon, and count 2, tampering with fabricating physical evidence.
Judge, I would argue there's no PC as to count 1, the robbery. Nothing was taken. He banged on the windows. There was no force used in taking anything. From what I understand in my brief conversation with his mother, his wife was at the business. There's some issue in regards to custody. Am I correct?
No, there's no issue regarding custody. Michael went to the business to pick up his wife. His wife gets out late. He walked over there to pick up his wife that works there. It was 3-something in the morning, and on the way back, apparently all this stuff happened. Somebody banged on a window. She was startled, and she called the police. 20 units arrived, to include a detective, Detective Link, Officer Browning, and so forth, and Sergeant Baker, who was at the scene also. She was trying to inform everyone, my child's home, I need to get home, and everybody was like, no. So, she's here today to try to square some of this stuff away. I have witnesses, the district manager, I have the store manager, I have a witness. Everyone says that there's video, but Michael's not on the video. Nothing was taken, nobody interacted, and that's the truth, ma'am.
Okay, and as to the tampering charge, is there any probable cause arguments as to the tampering charge?
Initial, sign, and date.
All right, as to the robbery charge.
First time, when I would agree it should be attempt, because nothing was actually taken. I do believe there is probable cause for attempted robbery. For strong arm robbery, you don't have to use force. It's force and threat. Clearly, banging on a window demanding money would cause concern for someone that they're being robbed. Why someone banging on the door wearing a mask also, trying to conceal their identity, demanding money. Secondly, the tampering is clearly tampering, Your Honor, because the fact that, according to this, he had a note on him that says, I have a bomb in the bag, empty the money in this bag or I'm blowing your shit up dead, shows intent. He was wearing the same shirt, and first off, I think for first appearance purposes, the only evidence the court could consider is that there are witnesses saying it's not him. Well, the person that's doing this is wearing a mask. So.
Judge, there's nothing in the 4 corners of the document that says that anybody even saw that note, the alleged note written. I don't even think it could rise to the level of attempt.
From the probable cause affidavit, I do agree that it was not actually taken or personal property.
Nobody interacted.
I know. Well, I have another question to ask the same thing. How many? How old are they?
Looking at the probable cause affidavit.
Judge,
as the charge of attempted robbery. Does the defendant have any prior criminal history?
Judge, in speaking with the family, they informed me that there is a drug rehab facility called Better Way that's ready to take him. He's been there before. Contingent on what the state says his prior record is, and I don't think he has a. He doesn't have a substantial criminal history. I would ask the court to release him in some form of pretrial release through his Better Way program.
How long have you been in South Florida for? 19 years. What's your address? Gutierrez, when you're done, just plant yourself somewhere. I'll get to you.
Firearm or knife?
Is there any way we could turn this down a little bit because it's kind of loud and I can't hear what's going on in the courtroom.
Roger Brown.
Alright, and what year was that?
2010.
2010.
Alright, what's the state's recommendation as far as setting bond?
Your Honor, I'd be asking for a $7,500 bond, which is actually the convenience bond, or the prior convenience bond for a strong arm robbery. I believe that's very reasonable considering his prior. I would oppose any type of just straight release, even to a rehab, because apparently he's gone there before, and I don't know how effective it really was, since now it looks like we're back here again, allegedly trying to rob a fast food franchise.
Judge.
Your Honor, he's at the end of the day, he's a father. Got his wife here, his mother's here. We're all here to help the situation. I don't know what more we can do. That was back in 2011. He's made some mistakes in the past, Your Honor. I agree with that, but ultimately, nobody interacted. There was nobody affected. It was one of those crazy little situations, and if we can just ask the court to bear with us a little bit and just try to help him versus try to prosecute him.
Judge, I would also add that his family members here and representative speaking on his behalf, it does show that he has strong ties to the community and they're here to help him. There is a program in place, and just my brief conversation with the mother, the court can impose conditions, place him on level 2 pretrial release, have him be on a strict schedule, and have a rehab component to as a condition of his release.
What type of substances does he have a problem with?
Marijuana, Your Honor, cannabis.
Frankly, Judge, I'm not trying to minimize, but I don't necessarily see a connection to someone smoking marijuana and deciding to rob stores.
All right, on count one, I'm going to set bond in the amount of $5,000. I do find probable cause as to the second count of tampering with physical evidence. Bond is set in the amount of $1,000.
Judge?
So total bond is going to be $6,000.
Your Honor, with the court, with the reduction of bond from the state's recommendation, would the court consider a GPS monitoring?
Your Honor, can we have a pretrial release with GPS monitoring?
No, I'm just going to have to post bond in the total amount of $6,000. I'm going to put him on level 2 pretrial with a GPS.
And we would just ask just an additional order, no return to the checkers located on Hillsborough and Deerfield.
Also, no return to the checkers, sir.
Thank you, Your Honor.
All right, thank you.
Judge?
He's on he can't post a bond. The family's indigent. His wife works at Checkers. His mother works for the airlines.
Well, what he can do is when he gets assigned to a regular felony division, he can file a motion and request the judge that's going to be assigned to his case to reduce his bond. But at this point, that's the bond that's going to be set in this time.
Aye, ma'am.
Judge, may I be heard, please?
Yes, Mr. Miller.
I would ask the court to reconsider count 2. I reviewed the probable cause affidavit. It says the police officer observed him tearing up a note. In order for there to be tampering with evidence, he would have had to know that there was an investigation going on, and he would have had to do something to the evidence in knowing that there was an investigation. If he was just tearing up a note, unless he knew that there was an investigation, there's no probable cause for witness tampering. I'd ask the court to reconsider the probable cause on that and to reduce the bond to ROR.
Mr. Linder?
I think it's reasonable to argue, Your Honor. According to this, he went to a store, concealed his identity, tried to rob the Checkers. When he was unsuccessful, he fled on his own. I think it's reasonable to believe that he knew he was getting away with it, and it's only reasonable to believe that the police are going to be on the scene. Why is he tearing it up if for no other reason than to not get caught?
All right, I note
Judge.
defense objections to finding a probable cause, and I overrule it, and I do find it to be a probable cause.
Thank you, Judge.
6,000, level 2 pretrial.
Okay, you have to sit over there and sign the
Thank you, ma'am. Have a beautiful day. Thank you.
Eva Candelaro.
North Broward, Judge.
North Broward, Your Honor. She's on the phone with the public defender.
Eva?
Here, she comes.
Candelora.
She's North Broward. She's on. All right, here she comes. She was on the phone with the public defender. Come on. There she is.
Hello. Good morning, ma'am.
Good morning.
You're here in regards to 3 separate matters. Count 1 is a KPS on a misdemeanor. Count 2 is also a KPS on a misdemeanor. And count 3 is a violation of my probation on a misdemeanor. Bond on count 1 is set in the amount of $250. Count 2, the bond is set in the amount of $100. And for violating my probation, you're being held no bond.
Judge.
Your next court date is going to be June 11th at 2:30.
I heard.
Judge, I understand that she's being held no bond as to count 3. The first 2 counts are municipal ordinances. Would the court consider resetting the matter until counsel is here from the city?
All right, reset until when? This afternoon?
Sure.
Okay. All right, we'll reset the 2 municipal ordinance KPSs for this afternoon.
Ma'am, can I ask you a question?
Yes, ma'am.
How did I violate a restraining order?
Violation of probation.
I wasn't on probation.
Yes, you were, ma'am. I placed you on probation, and then you just failed to report.
When? No.
I'll see you in court, ma'am.
Judge, in an abundance of caution with the
We owe anybody any money. Credit card, plus for the bills, department, stores, trust, whatever, everything loans. Put everything together, put one book inside that line. It's helpful. I'm over here. Carl Fenton. Good morning.
All right, Court Hudson.
Public defender.
Sorry.
Good morning.
Corey, come on.
It's Cody, actually.
Page 14,
they booked him as Corey, but it's Cody.
Okay.
Rachel, sorry.
You're here this morning on 2 separate matters. One, burglary of an unoccupied dwelling, unarmed, and count 2 of grand theft. All right, go ahead and state your name for the record.
Thank you, Your Honor. Rachel Newman from the Public Defender's Office. Thank you for taking me out of turn.
All right, sure.
Judge, I represent Mr. Hudson already on 2 other cases in Judge Singal. He was direct filed back at the same time as this case. For some reason, they no petition direct filed this case, but the not in custody capias has been sitting around since March. They're all related, well, not all related, but they all happened around the same time. He is out on level 1 on the other charges right now. Judge Singal actually ROR'd him recently with no objection by the state. His mom, she and I email 10 times a day. He lives with her, and he's doing well. I would ask the court if you would. We are already trying to work out his cases, and I believe close to a resolution on his other matters. I don't know if Your Honor would consider RORing him and placing him on level 1 on these, concurrent with the cases he already has. Ms. Saavedra is the prosecutor out of Judge Singal in this case.
And I checked his other case. I'll leave it in the court's discretion. I do see he was ROR'd to pretrial on, looks like late May, maybe
Yeah, it was just a couple weeks ago.
So I'll leave it in the court's discretion.
Okay. Are you on probation for anything?
We'll do with the case today. I have 2 orders here placing him back on GPS level 1 on those 2 cases, which are 152998 work dwelling and 153000 home invasion, robbery, and grand theft motor vehicle.
And Your Honor,
That's what this case today, whatever the court does, we're going to ask you to be placed on GPS on this one also.
and just noting for the record, I do see, Your Honor, that these allegations do predate him being placed on pretrial again by Judge Singal. So.
We've just been waiting for this one to get unsealed.
February 10th incident, 2015, and then the other burglary charge that was out on pretrial on when did those incidences occur?
Well, he was direct filed. I don't have the informations with me on those. I know they were all no petition and direct filed at the same time.
Okay.
Your Honor, I have I can tell you on the burglary he's out on, it allegedly occurred 4 days prior to this, but I can tell you that it looks like, from what I see, there was Judge Singal granted a motion to set bond in March of this year. There must have been some type of issue with pretrial because there was a warrant for failure to comply. But then, as we stated earlier, he then was placed back on pretrial a couple weeks ago. Level 1, from what I've been told.
That he did monitor because one of the orders said he could not be placed back on pretrial until he paid for our monitor.
That was Judge Singal had just said. There was nothing, he didn't ruin the monitor, tamper with it. He just said he didn't know at that time. We didn't know when we came in. So he said if in fact he had done something to it and damaged it in some way, he needs to pay for it before he gets released. His mom paid $25. There was nothing, and then he got back out.
He was ROR to pretrial level 2 GPS. Level 1, which is total lockdown.
Senia is. I don't know if the judges, because we've been waiting for it to pop up. It's been sealed.
All right. So as to these two charges, I'm going to ROR him to pretrial. Grand Theft has a $5,000 bond already set, so I'm going to ROR on that. Pretrial. Level 1. GPS.
Thank you so much, Your Honor.
Okay.
Thank you. Have a great day.
Judge, we invoke Mr. Hudson's right to remain silent. Also, Mr. Gutierrez.
Back on level 1 GPS on his other charges as well.
Thank you, Your
Judge.
Honor, and thank you, State.
Thank you.
Okay, you want to try again, Ms. Sanders?
Yara Hendricks.
She's present at the main judge. She has declined the public defender.
All right. In regards to a touch or strong battery, domestic violence, and an aggravated assault with a deadly weapon, I do find probable cause to detain you. Does the defendant declare?
What's your phone number?
This is a cross arrest, right?
When you get up there, tell him his name is Mr. Miller about your mom's phone. Okay, wait, listen.
How old are you?
25.
Mr. Hudson, turn around, face forward. Okay, do you have any other high cholesterol or anything like that? Who's walking? Initial here, initial here.
Okay.
Don't tell me to take your medication, like your sex medication. Okay?
I understand both parties are arrested. I guess my concern is more of a count two. A knife was allegedly involved. So I'm not necessarily asking for high bond, but some bond.
So what, your brain aneurysm? Were you injured when you were running?
Strike battery, domestic violence charge.
Want to take off? It doesn't matter. No, you don't take off.
Set bond on that matter.
You don't have to take off.
Aggravated assault with a deadly weapon without intent to kill.
Are you on probation? I don't find a free trial.
Application for police defender. Contact with a listed victim until further order of the
Children are already
court.
grown up, so you don't
Possession of firearms and ammunition, they need to be surrendered to the local police department.
How much did you say, minimum? 600?
Okay. $3,000 bond. Good luck.
You received, oh, you received Social Security, right?
Judge, Mr. Tran advises he speaks Vietnamese. We have asked for an interpreter. I'm not sure what the status of that is.
Workers' compensation. They have you called retirement?
They have not called us back yet, Judge. We don't know the answer to that question.
Priors?
You take medication, you receive a retirement compensation? I'm sorry? Every month? Okay, how much you see right there? No, right here. When's the last time you took them? Okay, any medical cash? Were you arrested with any cash? Okay, yeah. How much money you arrested? Okay. Mr. Jackson? He's still in the... Mr. Graves, Delroy? Right there. No, right here.
Yeah, actually, I'm showing multiple. Let's see.
Aggravated DUI in 2005.
I'm showing he was sentenced to 4.5 years state prison in Arizona for that.
This is on Tamtran?
Yes.
All right, I think we should, can we see if we can set this for the afternoon to see if we can get an interpreter here this afternoon? Okay, let's set this for the afternoon to see if we can get an interpreter. Henry Hendricks. This is the cross arrest.
Yes, Judge.
Decline PD, Judge.
All right, good morning, sir. You're here this morning for
Good morning, Judge.
strike battery, domestic violence. I do find probable cause to detain you. Does the defendant have any prior criminal history?
So let me know. She said
I hear what she's saying.
I can't, she's not saying anything.
I know, but before though.
Judge, was there a question?
I'm waiting to see if he has any priors.
Your Honor.
Roger that.
Were you elected by yourself? It says there. Do you have any children? How many do you have with your name on
Concealed weapon from the late 60s.
Yep, print it.
Wiggins?
On the line underneath you work, you're going to put your address.
I was 17 years old at that time.
Hold on to the paper with your hand.
Wiggins?
State's recommendation is to bond.
Your Honor.
Trying to have security on the form of.
May I?
I have no objection to a minimal bond. My biggest concern is that no contact order. Other than that, I'll leave the court
Next time, you're going to.
All right, sir, I'm going to set bond in the amount of $1,000. No contact with the listed victim until
All right, let me know. H-O-L-L-Y. You get assistance from the government.
Thank you, Judge. Off you go.
She said no contact. We both live at the same address.
Not, while this is pending, you don't.
Stephen Wiggins.
I guess she'll have to move.
Yeah. Mr. Wiggins is present at the main. He has declined the services of the public defender.
Okay, here for a capias on a felony charge, being held no bond. Next court date is June 22nd at 9:30.
Okay, go ahead and have a seat, okay? And when you call, just tell me about your mom.
Yes, actually, Your Honor, a bond.
I'm sorry?
If you have him come back, he needs to have a bond set.
Go ahead and sit where you're sitting. You're welcome.
Wiggins, you want a bond? Come back.
It's a not in custody.
Kendrick Mingo.
Okay. All right, why doesn't Mr. Wiggins come back?
Checking to see what count 1 is.
No Spanish.
Count 1 is being held no bond on a grand theft auto. Additionally, his priors include.
And if you decide to change your mind, which hopefully you will, then you can always sign up for public defense.
This is a case for failure to appear.
No.
11.
Cases on me, no problem.
Priors include possession of firearm by convicted felon, 06, battery, 07, battery, 06, resisting without violence, 05,
What kind of case is this?
battery, improper exhibition of a weapon, 04,
How do you say your first name?
2 separate grand theft autos,
Do you
03,
have a private attorney or do you want to sign up for a public defender?
97, robbery with a firearm with deadly weapon with the VOP, 4-year state prison. Your Honor, based on his, from what I can see,
Today's June 9th.
3 prior batteries, the robbery, and possession of firearm by convicted felon, I'd just be asking for a $5,000 bond, no victim contact.
Talk about your case.
All right, anybody here that wants to be heard in regards to Mr. Wiggins? Yes.
I do. I bonded him out on the last charge that he had for the grand theft auto, and he beat me up and put me in the hospital. I'm scared for my life. And that's what he's going to court for now, for beating me up.
All right, you want to go ahead and state your name for the record?
Irene Gonzalez.
You want me out?
All right. So he's out on bond on the grand theft, and then he picks up.
No, I'm not, Your Honor.
What happened?
I'm not on bond.
I'll check an Odyssey to see.
Initial.
I'm not in jail for nothing for her. So why is she even talking?
Just one moment, sir.
Initial, size, and date.
Okay, Your Honor, what it looks like, what happened was,
Lonnie Evan Graham. This is your initial here. Your birthday is 6/12/95. Yeah. You Gemini? Sure. We have to see the initials.
Yana?
You're here and here? This is not your kid. Your bond right now is $1,000. Fine. Are you on bond or pre-trial and another case pre-trial? Any cases? Are you on bond or pre-trial?
Your Honor, I can tell, what I can tell you is that it looks like he posted a bond on the Grand Theft Auto. The bond was surrendered, but he was originally arrested in that case. In January of this year, his bond, even though his charge was originally posted March 8th of this year, so these allegations would violate the conditions in that case, but it does not look like already held in bond.
Alright, so I don't have to set a bond on this.
No, on this one you do. On the Grand Theft Auto, it looks like he's already being held no bond, so there's nothing to report.
Grand theft charge is being held no bond?
That's what I see, yes.
Okay.
Yana.
Yes, ma'am.
For that one right there, he did have a bond, and I bonded him out. He didn't go to his court date,
You ain't
so
bond me out
then that's why they
nothing,
went to
man.
pick him up.
At the same time.
Talking.
Yes, ma'am.
He didn't go to his court date. That's why they picked him up for that. But I had bonded him out so that he can come out and do better and whatnot. And then I got beat up. That's why I'm scared. And I do not want him out here because I don't want to do too much with him.
Man, regardless of whatever you say, you can't keep me in
Looks
here.
like the capias was
Why you
issued,
keep
so
talking?
there's no, he's being held no bond on
Do you
that.
have an attorney?
Alright, but he is entitled to bond in this case.
Yes, Your Honor,
You're
and
gonna
what,
hold your own,
I
or you
guess,
want a public defender?
if I may, because I apologize, I wasn't aware, I didn't know the alleged victim was present, and based on the information she's providing, I would ask for a attorney's
You better let me know right now. I'm running it up.
Judge, I think there's
I
another
reject
issue.
that.
I know he declined the PD, but if you look at the booking photo and Mr. Wiggins appeared, it's not the same person.
That booking photo was taken April 2nd.
Booking photo because I got mace. Now.
Were you arrested by
That's not a
We're gonna
reason.
set bond and
Have you
amount of,
You live with you? The 0 pressed on heart?
5,000.
Do you work? Would you take home cash right
No
now?
contact with the listed victim, direct or indirect.
I don't want contact
Possession of
with
any
her.
firearms
I'm
or
good.
ammunition, They need to be surrendered to your local police department.
Tell her to go get a life.
If
Cut
and
that
when
way.
you get released.
You gotta keep the Social Security on the form and work with
How is it Yuriano? Okay.
Liriano declined the PD, Judge.
Dwelling, vehicle, or building, or aircraft. Any probable cause to
No.
have any prior conviction.
No, circle within the video person on flash.
Yes, it's 2,000, 4 counts of grand theft, 1 count of petty theft, and 5 counts of criminal use of personal identification information, 2002 possession of marijuana.
I'm sorry?
Yes, just talk to the judge.
And that's the date of birth. Yes. Here's how much money you have in your bank account. Fine print, reduce city, the rest phone number.
Well, based on the allegations in this case, his prior record, I'd be requesting a $6,500 bond, no victim contact.
No, you are your own individual.
All right, sir, I do find probable cause to detain you.
Oh, yeah.
Your Honor?
5,000.
Your Honor, if I may address the court for just a moment.
Yes, sir.
These are allegations, and as you can see, I haven't been in trouble with the law since 2000. If there's any way possible that, for whatever reason, you can find it, that you can drop or lower the bond amount. I'm a law-abiding citizen. I've been in the state of Florida for the last 20 years. I have a respectable job. I'm a regional sales manager for a spice company.
and you know, I'm not a flight risk of any sort. You know, I plan on taking care of this matter as soon as possible, but I would like to be able to go home today and you know, take care of this if you can, please. Much appreciated.
In order to be released, sir.
Thank you very much, Your Honor.
Good luck. Brown? All right, sorry. Have a seat, Mingo. I think he declined the PD, Judge.
Mingo, you're here for one battery causing bodily harm and domestic violence case.
Just
We just skipped forward to 11.
Just have reckless driving from last year, Judge.
Jamal Long.
I was on ATV.
Okay, all right, I'm going to set bond in the amount of $1,000. No contact directly or indirectly with the listed victim. You're in the possession of any firearms or ammunition. They need to be surrendered to the local police department.
Thank you, Judge. $1,000. Mr. Brown is president of Maine.
First degree, property 1.
Eric, is this a non-custody KPS or is this a failure to appear?
How much is bond for them?
He's just going to set it down.
Just let her know. I ain't never know nothing about these charges right here.
You had
Do you have any children?
resisting without violence 07, resisting without violence 07, felony battery, great bodily harm, and false imprisonment 05, 17 months state prison as a habitual offender, delivery of cocaine 2002, 2 years state prison, 02, possession of cocaine with intent, 2 years state prison, possession of cocaine 99, multiple other drug priors, Your Honor, 93, he had another battery. Your Honor, based on his priors and the allegations in this case, that he punched the alleged victim in the mouth, breaking her front teeth, that kicking the alleged victim while she was on the ground. The allegation is that she was 8 weeks pregnant with his child and he was aware. Your Honor, I'd be asking for a $20,000 bond on count 2, $5,000 bond on count 3 with pretrial release of the GPS monitor.
Judge, Mr. Brown is a lifetime resident of South Florida. He's got a job working for a tree service. He's been doing that for 5 years. He has one child that he takes care of, a 1-year-old. He's got 5 other children that are grown. Strong family ties, does have a place to stay separate from the alleged victim. He's going to have to self-bond, Judge. This is a already 4-month-old case he didn't know anything about. I would ask the court to set the bond at $1,000 per count, and unless there's some showing that he's missed a lot of court dates.
I just got out of the hospital yesterday.
GPS is not necessary. He's, as I said, it's already been 4 months since this case was initiated, and there have been no reoccurrences of these charges.
At all. And I just got out of the hospital yesterday, man.
Your Honor, I would also just note, he's been arrested 3 times in the past for failing to appear in court.
Are you married, single, or divorced?
As to the aggravated battery, offender knew or should have known the listed victim was pregnant, going to set bond. That matter.
People think we need to hustle and ask to come back. Who do you live with?
GPS.
A job? Where's the address?
Battery, second, and of course subsequent offense.
All of this is going to bounce back.
That will also be $10,000
phone number.
to GPS.
Being lazy.
Contact.
Good luck. Eric Reese. President, the main judge declined PD.
With intent to commit a felony, dating violence.
Jimmy Jacob. Thank you. Jimmy Jacob.
I do find a probable cause to.
Medicaid and Social Security disability. Are you a veteran? Are you issued to be arrested?
Your Honor, it appears he has no priors. In this instance, because of the allegation that a firearm was involved, it also appears that there were two independent witnesses that corroborated the alleged victim's version of events. I'd be asking for a $25,000 bond, pretrial release, GPS, no victim contact.
I ain't worried about it.
Alright, sir, you find probable cause to detain under $10,000.
Veterans benefits,
What? She just set the bond. She's not going to drop the bond. She just said it. She's not going to lower it. Off you go. How much? 10,000. Good luck. Don't go down. President, the main judge will invoke his right to remain silent.
Alright, so you're here for two matters. Count 1 is touch or strike battery, domestic violence. And count 2 is robbery without a firearm or weapon. I do find probable cause to detain you.
Are you on probation? Are you on probation? Pending cases. What county? Out on bond or withdrawal? Are you out on bond or withdrawal?
Your Honor, the defendant was arrested in January of this year. January this year for domestic violence battery by strangulation against the same alleged victim. The charge was dropped. Bond in that case was set at $7,500. I would just be asking for a on count 1, 1,000, count 2, 6,500, and no victim contact.
Okay. Mr. Miller, you want to add anything?
How long have you lived in South Florida?
All my life.
And are you working?
Yes.
Where do you work?
I work at Home Depot.
How long have you been there?
For a year.
Okay. Do you have any children?
Yes.
How many? 3
that live with me.
And you take care of them?
Yes.
Okay. Family in South Florida?
Yes. Brother.
Do you have any money in the bank?
Yes.
Okay. Judge, he's a lifetime resident in South Florida. I would argue ask for bond 1,000 per count.
Ready to set bond in count 1. 1,000. Count 2 is the robbery, no firearm or weapon, in the amount of $6,500.
Thank you, Judge.
I wasn't. I mean, I'm not opposed to it.
Okay, all right. No contact, direct or indirect with listed victim. In the possession of any firearms or ammunition, they need to be surrendered to your local police department.
Thank you, Judge.
All right. What about with the third child?
7,500. Sherry. Bonded.
Bonded?
Yes, Judge.
Escobar.
Charity Jackson.
President, the main declined PD.
All right. Good morning. You're here for a violation of probation on a felony charge. You're being held no bond. Your next court date is June 15th at 8:30.
Look. Renee.
Rochelle Myers.
North Broward, Judge.
Michelle Myers. Okay, good morning.
Good morning.
Here for violation of probation on a felony charge. You're being held no bond. Your next court date is June 15th at 8:30.
Thank you.
You're welcome. Renee Legale.
President, the Maine declined PD. Taisha.
Good morning.
Good morning.
Here in regards to a burglary with an assault or battery.
Your Honor, this is actually, you might recall, this is the co-defendant of the other defendant that Mr. Melnick was representing yesterday.
All right. All right, I do find probable cause.
And Your Honor, the state is going, and I understand that Judge Orlando put a $50,000 bond on this. However, it is a punishable by life felony, and if the state moves to foreclose and the court finds that there is proof evident or presumption great, by law she should be held no bond. Your Honor, I would be seeking to foreclose and arguing that there is proof evident or presumption great based on the probable cause affidavit. There are independent witnesses that corroborate the alleged victim's version of events, and additionally she identified the co-defendant via a photo lineup. So, Your Honor, I would argue that based on the allegations, she's a principal, and I would just be asking for the court to find there's proof evident.
All right, but what about the setting of the bond?
Well, here's the thing, Your Honor. And I believe the court, first off, the court can, on an arrest warrant that hasn't been...
It's still discretionary, right?
Well...
If I find proof of guilt evident presumption great, it's still discretionary.
Well, Your Honor, the state's position is respectfully, it's not, and there are several reasons. One, there's only one type of hearing in which the court, if the state satisfies proof evident or presumption great, that the court then has discretion to take evidence and decide to set a bond. It's an Arthur hearing. This is clearly not an Arthur hearing, it's just a first appearance hearing. The reason being is that the state may choose to present evidence, call witnesses. Secondly, there is an administrative order in the circuit which states that if the state satisfies its legal burden, that the court shall not set a bond on a punishable by life felony or capital offense, and that it shall go to the assigned division pursuant to State v. Arthur. Now, admittedly, the administrative order incorrectly states that if the court finds probable cause. However, the clear intent of the administrative order, Your Honor, is to establish that if the state satisfies its legal burden, that no bond be set at first appearance. Whether it's probable cause or, as all sides agree, proof evident or presumption great.
Judge, may I be heard, even though I'm not on this case? It is a matter of some importance. We believe that the state's interpretation of the rule is incorrect. There is a case, the Preston decision, which we believe gives the court discretion to set a bond even if proof is found or proof is evident, presumption great is found. We still have the discretion, we believe, under Preston to set a bond in a first degree PBL case.
And I would be more than happy, and I can print out a copy of Preston because I believe the defense and myself has a very great disagreement in the holding of Preston. My
And Judge, furthermore, we believe that Preston overrules the administrative order.
Well, I think we can both agree to wait till the judge is done reading Preston. Okay, well, Your Honor, the state's position, since you're familiar with the case, is the holding of Preston is that the court found that at the Arthur hearing, the court should have never found that there was proof evident or presumption great. That is the holding of Preston. the language that I believe the defense relies upon is a portion, is dicta in the case, where the court says that if a writ had been filed, or we would have set a bond at the first appearance. But clearly, what that means is, logic would dictate they would have been entitled to a bond at the first appearance because the state couldn't have satisfied proof evident or presumption great at the first appearance. If the court found that the state couldn't satisfy proof evident or presumption great at the Arthur hearing, they wouldn't have been. Then the court naturally would have found that they couldn't find it at the first appearance. Nowhere in that case does it ever say that a court has discretion to set a bond at a first appearance if the state satisfies proof evident or presumption great. The case merely holds that if the state doesn't satisfy proof evident or presumption great, a bond must be set.
Judge Orlando signed this affidavit on what date? June 4th, 2015, just 4 days ago. Circuit Court judge reviewed this affidavit to arrest. And sure he's fully aware of the legal standards associated with this type of charge. And decided in his discretion to set bond in the amount of $50,000 on this warrant.
And I guess, Your Honor, the only thing I would say is we have cases in here sometimes where judges on an arrest warrant, on an aggravated battery, for instance, would set it at no bond. And I think the defense would even agree. In a case like that, even though the judge that signed the arrest warrant set it at no bond, the defendant by law is certainly entitled to a bond.
All right, I'm not going to make a finding as to proof of guilt evident, presumption great. There was a circuit court judge here who reviewed this affidavit very recently. And
yes, Your Honor.
On June
Judge,
4th,
I believe Ms.
just 4 or 5 days ago, in his discretion, set a bond in the amount of $50,000. If the state wants to file a motion to have that bond reconsidered in front of the appropriate judge and to have her held no bond, they can file that motion. But at this point, I do find probable cause, and the bond is set in the amount of $50,000.
Okay, thank you, Judge.
Judge, I believe that Ms. Legale would like to address the court.
Okay, go ahead. Yes, ma'am.
When I was picked up, I was aware that I was supposed to be talking to somebody when I came in as a witness.
All right. Well, at this point, your bond is set in the amount of $50,000. You're not to have any contact with the listed victim, direct or indirect. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department.
Ms. Vaughn. Good luck.
Aisha Vaughn.
Present at the main, she has declined the PD.
Good morning. You're here for 3 matters. You have 2 cases on 2 separate misdemeanor charges and a violation of probation on a felony. Bond has been set in the amount of $500 on count 1, ROR on count 2, and violation of the probation on the felony. You're being held no bond. Your next court date is June 11th. And as to the VOP, it's June 12th at 8:30.
Thank you, Judge. Cynthia Irwin.
Cynthia Irwin.
She bonded, Judge.
Kasheep Campbell.
North Broward.
She's a medical reset, Your Honor.
All right. Thank you. Takia Flash.
Medical reset, Judge. George Montgomery. George Montgomery.
George Montgomery.
Deputy Hardy, the doctor is still in the back.
Page 9, Montgomery. Medical reset on Mr. Montgomery, Judge. Tyrone Gauze. Come on up.
Tyrone Gauze.
Present at the main.
Good morning.
Bond is set amount of $100 on count 1, and bond set amount of $250 on count 2. Your Next
Judge.
court date is June 11th at 2:30.
Judge, I'd ask the court to reconsider count 1. In order for the state to convict someone of obstruction by disguise, there actually has to be a disguise, and in this case, I don't see anywhere on the probable cause affidavit of any kind of mask or anything being used by Mr. Gauze. So I'd ask the court to find no PC on this charge.
Yeah. When you just tell me one.
Your Honor, there's still probable cause for obstructing law enforcement officer without violence.
Okay. All right, I do find probable cause, and his bond, as I stated previously, set in the amount of $100 and $250 respectively. Charles Dunlap.
This is Mr. Dunlap, Judge. This is a misdemeanor. Okay. You have to take it to missing a court. Okay, you have to take it up with the division judge. This judge doesn't have any authority over that phone, which I explained to everybody.
It is Fort Lauderdale.
So
We're
you got the
usually
new
here
truck.
in the afternoon. I understand Mr. Adrian was here yesterday morning,
And
but
then
I was just asked to reset it and run some caution for them to be present.
All right, so you're here at Mr. Previous bond is set in the amount of $500. Your next court date is June 16th, 10 a.m. And we'll set this matter for the afternoon to see if we can get the assigned prosecutor on this case here.
Go home. No, you have to. You can bond out, or you can come back this afternoon. See you after lunch. Roney. Judge, this is a Spanish language defendant. I understand there is no Spanish language interpreter available today.
All right. We call?
Yeah, you can call me back.
We're going to try and contact an interpreter now.
Siéntate, por favor. Eric Hansen. Eric Hansen. Page 9, Hansen.
Eric Hansen.
Medical reset, Judge.
All right, the interpreter's on their way.
I'm sure.
Thank you, Judge.
Fabian.
Medical reset. Michael Brown. President of the Maine, Judge. This is a misdemeanor ordinance, municipal ordinance case.
Okay. All right, so you're here for
Good morning, Your Honor.
Good morning, sir. You're here for a municipal city ordinance violation. I do find probable cause. Bond has been set in the
What is it?
$25 bond.
Is there any way we can resolve this today? I have.
To ask that lady.
Okay, because I have an appointment with Housing Authority tomorrow.
Oh, okay. All right, man. Well,
Why don't we reset this for the afternoon because there's no assigned prosecutor.
She's going to try to reset it for the afternoon so that she can.
No. This is not in reference to him. On the previous case with Mr. Habian, who's currently on loan, you're Brown? I thought you were asking for Habian. Okay. All right.
Michael Brown.
Your Honor.
All right, pre-trial, you were talking about Mr. Brown, right? Okay, all right, but we don't have the city prosecutor here, so let's reset this for the afternoon.
Your Honor.
I'll see this
I
afternoon.
have
We need to get the assigned prosecutor. Next
Okay,
case,
I have an
George
appointment with Housing
Storchenko.
Authority tomorrow.
She's going to
Bond out
set
if
your
you'd like
case
to.
for the
We have a bond
afternoon.
on it. Otherwise, we'll see you
She's going to reset you for the afternoon.
Today?
Today.
Okay.
George Storchenko.
He's president of the Maine, Judge.
Morning, sir. You're here also for a municipal city ordinance violation. I do find probable cause. Bond is set in the amount of $25. Bond out on that charge. In the meantime, let's set this for the afternoon for the assigned prosecutor to be here.
Thank you, Judge. Stephen Maliani.
I don't have anybody to bond me out.
You're coming back this afternoon, sir.
All right, Mr. Maliani, you're here for trespassing, entry on property unlawfully. I do find probable cause, bond is set in the amount of $25. That's not enough.
Judge, any chance of resolving this one?
No, 10A.
Is that a no?
Does he have prior state?
March of this year he had trespass. February of this year he had petty theft. January of this year he had grand theft. Another trespass in January. Yes, from 2014 he has several trespasses.
All right, I'm not going to resolve this today.
Okay. Invoke his right to remain silent. Darren,
All right,
Thomas.
bond has been set in the amount of $25.
Thank you, Judge.
Can I explain?
Darren Thomas.
Judge, Mr. Thomas is present at the main. We invoke his right to remain silent. Any chance of resolving this one?
All right, sir, you're charged with trespassing, occupied structure, or conveyance. I do find probable cause, bond is set in the amount of $100. Unless you have any priors.
Last year was trespass.
That's one.
Trespass. February of last year trespass.
I clean up there, man. Can you explain? I clean there.
What?
I clean up there.
Okay. That's your defense. That's not for bond day. Today's just about the bond.
How much do I want? It's $25.
$100.
All right, I'm not going to resolve this today. His bond is set in the amount of $100.
Thank you, Judge.
Hey, ma'am, I'd like to explain something.
No, sir.
I clean up.
Next case, John Fultz.
Mr. Fultz is President of Maine. Invoke his right to remain silent.
All right, good morning, sir. You're here for trespass, failure to leave property upon order. By probable cause, bond is set in the amount of $25.
Any chance of resolving this one, Judge?
November of last year he had trespass. Then 2014 he had disorderly conduct.
This isn't an MO, right? Okay, it's private property. All right, what's
Yeah, it looks like this is a business, Your Honor. I would offer that time served.
All right, does he want to take time served?
Yes, Judge.
How long has he been in? 2 days, a day?
According to the booking report, he was arrested on the 8th at 5:15.
Okay, all right, Mr. Fultz, want to raise your right hand? Raise your right hand, sir. Swear affirm, tell the truth, the whole truth, nothing but the truth.
Yes, I do.
All right, place your hand down. State your name for the record. State your
John
name for the record,
Fultz.
sir.
John Fultz, Jr.
All right, do you want to plead no contest to this trespassing charge?
Yeah.
All right, I'm going to adjudicate you guilty, sentence you to 2 days in the Broward County Jail, credit for 2 days served.
What's your name?
2 days, credit for 2 days.
Oh. So I'll get out today?
Court cost mandatory fees are imposed.
Okay, thank you, Judge. Good luck. Decline PD, Spanish. Siéntate, por favor.
DUI with damage to property or person?
Judge, I'm sorry to interrupt.
Interpreter?
Yes.
Okay, the interpreter's on their way. We'll
Thank you, Judge.
Jacob?
Mathis. It's President of Maine.
Tell them they're mistaken about this.
This is
Yes, ma'am.
No, y'all wait.
Can we resolve it? I've been here 4 days.
This is a municipal ordinance case. It's between you and the judge.
Municipal ordinance case, the assigned prosecutor is not here, so we can reset this for the afternoon. If he wants to see if we can resolve it.
Thank you, Judge.
All right.
Off you go.
Alexander Coughlin,
North Broward,
North
Judge.
Broward, medical reset.
Padero.
All right, so he's not there?
It's a medical reset.
All right, thank you.
Clifton. For
Conti.
Conti.
Okay, Mr. Ferrer, you're here for a fourth count of a habeas on a felony. It's a no bond habeas. Is that for failure to appear? It's an ad charge. Is he entitled to bond?
One moment. Who is this? It's for, yeah, no. For aggravated assault, it is bond eligible.
Does he have priors?
Ivy, could you tell me what's he's being held on count 1 and 2, please?
Yeah, count 1 armed burglary and the second one count 2 possession of cannabis.
Is he being held no bond on the first count? All right.
Yes, he is. Count 2 possession of cannabis, 1,000. Count 3 violation of battery domestic, no bond. So yeah, he's being held no bond on count 1 and count 2.
I just asked for a $5,000 bond, you know.
What is this felony that we're expecting habeas on?
It's an looks like this is an ad charge, right?
Ag assault with deadly weapon.
Charge.
Yeah.
It's an ad charge. It looks like it's added onto it his other charges.
But what is it?
This new charge, it's aggravated. You mean what's the charge or what's the allegation?
What's the actual charge? What is the felony?
Aggravated assault.
Aggravated assault.
Yes.
Because I don't have a PC for that.
If you'd like, I can. Ivy, do you have the original report? Because it's probably based on that. No. I'll check right now, Judge.
Okay. All right. Okay.
Okay. Your Honor, if I can print out this report, I can, if you want me to proffer.
Why don't you proffer to me what the allegations are?
Your Honor, on February 23rd at about 12:49 p.m., law enforcement BSO was dispatched to a residence in Tamarack where there was a disturbance call, subject threatening caller with a gun. When the police arrived, they observed the defendant. He was detained. Listed victim stated that Ferrero, that the victim owed Ferrero money, that Mr. Ferrero went to his home, entered his home unlawfully, entered a front screened-in porch, armed with a knife, and threatened him with the knife, demanding the money he was owed.
Okay. All right, and what's state's recommendation as far as bond?
Your Honor,
5,000,
based on his other no bond holds, I'm fine with the $5,000 bond, no victim contact.
All right, sir, I'm going to set bond on this ad charge in the amount of $5,000.
All right, ma'am.
No contact, direct or indirect, with the listed victim. If you're in possession of any firearms or ammunition, they need to be surrendered to your local police department.
Yes, ma'am.
Daniel Clifton.
Judge, President of Maine, according to the docket, Judge. This is count 3. The capias I have in my hand here only has counts 1 and 2. I'm not sure what's going on here, but I don't think...
He's on felony, and I don't have any police report in regards to this case either.
He is actually, I just want to confirm. Yes, he's Mr. Ferrero's co-defendant, so it's the same allegations. He was present with him when this occurred.
All right.
And as far as counts 1 and 2,
can you actually, so I can write down my co-defendant name? His name is Stefano or something. I don't know how to spell his first name.
$100 bond on misuse of 911, and I see he's got a
Thanks.
He's also being held on the same armed burglary dwelling.
Okay, so state of the recommendation is to bond.
I would just be requesting the same bond. 5,000 is could have been.
I don't have the police
again,
report, so I don't know what he's alleged to have done.
Your Honor,
other than what you just proffered to me about the co-defendant.
Okay, one moment now. According to the victim, both Ferrero and Clifton forced their way into the house by overpowering the victim, who was trying to hold the door closed. It says that Ferrero was armed with a knife, and Clifton was armed with a hammer.
All right, I do find probable cause to detain him. I'm going to set bond in the amount of $5,000. No contact, direct or indirect, with the listed victim in this case, and your next court date is going to be June 11th at 8:30. Also, no contact, direct or indirect, with the listed victim, and for the possession of any firearms or ammunition, they need to be surrendered to your local police department. All right, we have the interpreter present.
Judge, before we move on, I'm invoking Mr. Clifton's right to remain silent. However, it appears he wishes to address the court. Would that be allowed?
Sir, don't speak about the facts of the case. What would you like to tell me?
Hello, ma'am. I'm a law-abiding citizen. I was just wanting to know if I can have pre-trial.
No, sir. Your bond has been set in the amount of $5,000. Okay,
All right.
we have the interpreter here on Diego Felipe Correa Escobar.
President, the main judge. Decline PD.
Okay. Good morning, sir.
Buenos días, señor.
Buenos días.
Está aquí para dos asuntos. El primer asunto es manejar bajo los efectos daños a la propiedad o persona
And also refusal to submit to a DUI test.
y negarse a someterse a la prueba de manejar bajo los efectos.
I do find probable cause to detain you,
Hay un motivo justificado para detenerlo
and your bond is set in the amount of $1,000.
y su fianza se fija en la cantidad de $1,000.
Judge, I was just informed that his wife is posting his bond.
And your wife is posting your bond, so you should be released shortly.
Y su esposa está depositando la fianza, así que va a estar en libertad en corto tiempo. Buena suerte, señor.
Gracias.
All right, next interpreter case would be Ronnie Godinez.
He's present at the main judge, also declined the PD.
Good morning, sir. You're here for a habeas on a traffic charge.
Señor, está aquí para una orden de arresto por un cargo de tránsito.
Your bond has been set in the amount of $500.
Su fianza es $500.
¿Quién habla solamente español? Sí.
Yes.
All right. You can bond out and
Puede
answer to those
salir
charges, sir.
bajo fianza y encarar los cargos, señor.
Okay.
Okay.
Carl Fenton?
President, the main judge. Adios.
Are you going to speak for me or you want me to speak for myself?
Anybody else require the services of the Spanish interpreter there? Mr. Miller?
Not at the main jail, Judge.
All right. Anybody else? All right. Hearing nothing.
Okay.
Thank you, Interpreter.
Judge, with regards to Mr. Fenton, I would ask the court to do a mental health screen.
Mr. Fenton?
Yes, Judge.
Why did I have that set aside? He was next? Okay. All right, Carl Fenton. All right. Good morning, sir. You're here for an ad charge. It appears you're being charged with fraud. Planning to participate in a vehicle accident, making false claims. I do find probable cause to detain you. Bond has been set in the amount of $1,000, and you're requesting an evaluation.
I previously.
Judge, Mr. Fenton is advising me that he's retired and that he takes care of his 90-year-old mother, and that there's no one else to take care of her. So we'd ask the court to consider pretrial release for him.
It's not going to make a difference, Your Honor. I'm showing he's being held no bond.
He's being held no bond on. Can you tell me what it is?
Yes, of course. He's got another open case. It's court order. It's a court order from 2012 case, insurance fraud by false claim.
Okay, he's got an insurance fraud case he's being held no bond for.
Thank you, Judge.
The new case, according to the police report.
The old case.
The new case. The reason why I'm held in no bond is because the guy perpetrated the accident. But the police report says that the guy was cited for running the stop sign and hitting me.
Okay.
Devaney Graham. All right, Mr. Graham, can you hear me? He's got me muted.
Dale, put on the mic.
Sorry, President Domain. You're going to have to go now.
Mr. Graham, you're being charged with possession with intent to sell.
You giving him a number, Dale? Right there on the car. Okay, that's it, sir. Go that way.
Assisting an officer without violence and also loitering and prowling. I do find probable cause to detain you. The total bond is set in the amount of $1,000.
Thank you, Judge. Good luck.
Mark,
what? Do you think you go out the door?
Benjamin Nelson Marsh.
Can I ask you President Domain?
All right, good morning, sir. You're here on two matters: a violation of probation on a felony and an expired tag less than 5 months. The violation of probation on the felony charge, you're being held no bond. Your next court date will be June 15th at 8:30. Jermaine Jackson. Okay, Mr. Jackson, can you hear me?
In jail.
Yes, ma'am. You're here for several capiouses. You have 5 capiouses. The first 2 capiouses are on felony charges. The 3rd, 4th, and 5th capiouses are for misdemeanors. You're being held no bond on the first 2 capiouses, and your bond on the last 3 capiouses is set at $500 respectfully. Your next court date is June 15th at 8:00.
All right, go ahead and give me 2 driver license in it.
Okay, 2 different cases. Off you go. Good luck. Present at the main judge, Louis Peranti is his attorney.
For violation of probation on a felony, you're being held no bond. Your next court date is June 15th at 9 a.m.
Thank you, Judge. Off you go. Mr. Whitehead.
Donald Whitehead.
President of the Maine. Yes. Roger Brown.
For violation of probation on a felony, you're being held no bond. Your next court date is June 15th at 8:30.
Yeah, he is entitled to a bond on count 1, Your Honor.
Violation of probation.
Oh, I'm sorry. I was on the wrong thing. Sorry.
Okay, all right. You'll be set a bond or what? Or I get in trouble?
I don't want that.
Roger Lennar Brown.
Yes.
All right, good morning, sir. You're here for a burglary, unoccupied dwelling, grand theft, and a habeas on a misdemeanor. I do find probable cause to detain you. Bond on the grand theft has been set in the amount of $1,000, and on the habeas on the misdemeanor, it's $250. Does the defendant have prior conviction?
Yes, Your Honor. 2010, possession of cocaine. 03, battery. 99, possession of marijuana. End of record.
All right. Does the state have a recommendation for bond?
Your Honor, based on the nature of the offense and his prior record, I'd be asking for a $10,000 bond.
All right, sir, on count one, I'm going to set bond on the amount of $5,000. Your next court date is June 19th at 10 a.m. Total bond amount is $6,250. Kevin Miller.
President, the main judge.
All right,
Oh, hey.
You're charged with burglary with an assault or a battery and a habeas on a misdemeanor. I do find probable cause to detain you. Yes, would you like to state your name?
Inspector Jacobs.
Okay.
He was arrested by Fort Lauderdale yesterday for striking a postal employee assault, and we wanted to get with the prosecutor after the case.
Okay.
Make sure he doesn't bond out.
All right. Well, at this point, due to the nature of the charges, burglary with an assault or a battery, I do find probable cause to detain him. He's held no bond.
Your Honor?
Yes.
And the state's going to be seeking to foreclose on proof evident or presumption grade. I would concede the court does have to find, based on the report, that there is proof evident or presumption grade in order to hold no bond. I would argue that I believe, based on these allegations, that there is a statement was taken or information was obtained from the alleged victim, specific information. There's physical corroboration, the injury that she was suffering to her head. She gave specific information, specific statements the defendant made before he struck her with what appears to be a transistor radio while she was in her vehicle, Your Honor. She identified him. She gave a description of him that allowed the law enforcement to identify him. And then she was, one moment, Your Honor. She was brought to the scene for a show up and positively identified him.
All right, Mr. Miller, do you have anything in contradiction of that?
Judge, I would just argue that a show up is at best a questionable way of identifying anyone, and that eyewitness identification is one of the leading causes of wrongful convictions, and based on that, I would argue there is no proof evident presumption great. This is a matter for a jury to decide.
All right, I do find proof of guilt is evident, presumption of guilt is great, based upon the reading of the probable cause affidavit. He's held no bond, and his next court date on the case of the misdemeanor is set for June 19th.
Judge, would the court appoint counsel in that case?
Yes, I will. I will appoint the public defender's officer.
Oh, okay, never mind.
Tristan Andrews.
North Broward.
All right. Tristan Andrews.
North Broward, medical reset.
Okay. Delroy Greaves.
Main jail.
All right, good morning, sir. You're here for possession of cocaine, a seatbelt violation, and probation
Really?
violation, community
Your
control
name? Oh, yeah.
violation, and a felony case. You find probable cause to detain you on the possession of cocaine. The case is set in the amount of $1,000, and you have no bond hold for the violation of probation. Your next court date is June 11th at 8:30.
Goodbye. Willie?
Willie Lundgren.
Yes, ma'am.
All right, sir, you're here for the charge of robbery, firearm, or weapon. I do find probable cause to detain you. Does the defendant have prior?
He's showing he's on probation.
All right. State have anything else? All right.
Sorry.
All right, so he allegedly stole a bike.
And
The state of
Judge,
recommendation.
Based on his prior record and prior alleged violence, including an attempted murder in his past, I'm going to be asking for a $50,000 bond pretrial release with the GPS monitor.
Mr. Miller, anything you want to add?
Judge, according to the probable cause affidavit in this case, Mr. London was recovering or attempting to recover property that was stolen from him. According to him, that was his bike and he was recovering it. So that would make this, if that's true, not a strong arm robbery. And so I would argue, Judge, that there is a difference of opinion as to whether or not that was his bike, and that a $50,000 bond is not warranted. I would ask the court for ROR in this case.
All right, I'm going to set a bond in the amount of $5,000.
Thank you, Judge. Okay, off you go.
How much did I think of that?
500.
Okay.
Jamal Long,
All along.
President Domain.
All right, good morning, sir. You're here for two cases, one on a misdemeanor charge and the second on a felony charge. Well, actually, one is on a traffic criminal charge and the other is on a felony charge. Bond on the traffic criminal is $250 and on the felony charge is no bond. Your next court date is June 15th at 8:30.
Oh, okay. Thank you, Judge. Frederick? Monday. For the third time, Monday. President Domain.
All right, good morning, sir. You're here for possession of cannabis 20 grams or less and a probation violation. Probable cause bond is set on $100 on account 1 and on account 2. Your next court date is June 16th at 8:30.
Thank you, Judge. 16th, that's correct.
Donald Wilson.
North Broward.
Okay, Mr. Wilson, you're here for possession of PVP. I do find probable cause to detain you. Bond is set in the amount of $1,000.
Thank you. Look at that.
Manuel.
Medical reset, Judge.
Rodriguez. Valcalcere.
And medical reset, yeah.
And then I have two perfections. Frederick Klein.
Frederick Klein is president of the Maine.
Ecstasy, is he here? Frederick Klein?
Maine jail, Judge.
Okay. Possession of MDMA and possession of controlled substance.
Is that
as the ecstasy is concerned, the MDMA, what's, is there any probable cause arguments?
Your Honor, on whatever counts were found that there was no PC over the weekend, I have nothing new to add to them. So.
Okay, all right, because it just, because the police report just is very conclusory that he was in possession of these substances without any field test or drug recognition expert or anything like that. Yeah. So at this point, as to the possession of MDMA, possession of controlled substance without a prescription, what substance was that he didn't have a prescription for?
Your Honor, frankly, I don't even have the PC.
He was in possession of 8 grams of marijuana, but that's not something good. Well, you could get it.
It could, but I still would have.
Ecstasy calls it clear plastic baggies and a controlled substance in the form of pills in clear plastic baggies. It doesn't say what those pills are. So at this point, I do not find probable cause as to either of these charges. So today, sir, is your lucky day. I'm going to ROR you on both of these counts. Doesn't mean the case is dismissed, sir.
So this would be, I'm sorry, this would be on Councilman Florida?
It's 2 and 3. Okay. And he's, what is the bond on 1 and 4, do you know?
25 on 1, 100 on 4.
All right, so it's $2,600 total on your, on
$25.
$25?
100 on 4. Okay. 125 total.
$125 total to bond out of jail, sir. But on these 2 charges, the possession of ecstasy and the possession of controlled substance, I'm RORing you. I find that there's no probable cause.
Yeah. You made that a lot more awkward than we had.
Mark on here that there's no PC.
I think it already was.
Yeah. Valencia Weldon.
Your Honor, on the first page, again, mentions the pills, and then on the second page, well, do you know where she is?
Valencia Weldon, is she there?
She's at Paul Ryan, Judge.
Valencia Weldon. Did she bond out?
No, I'll check. They usually take her off the docket if the person bonds, but I'll check.
Sure she's at Paul Ryan?
I'm checking everything.
Judge, was there any additional information provided in this
at Paul Ryan. It's showing that a bond is not posted.
Was not posted?
No. On the second page, it mentions that the pills were identified by Florida Poison Control.
All right, but she's not here. She's not on video. She's magistrated.
Oh yeah, no, I have no problem with her being brought back. I just since she only gave us 24 hours.
Right. Okay. All right. So let's see if we can get her for the afternoon. Now. Let's present this for the afternoon.
All right. That's it.
Is that everything?
Yes, ma'am.
Okay.
Yes, ma'am. See you after lunch.
All right.
No, you go.